Coming up, I'm going to introduce you to uh, a lawyer. Oh, well, it's not that we haven't had any lawyers. No, but in an extraordinary case that was settled, well, that was published yesterday after, I think, 8 days of hearings, only last month, in front of the Supreme Court. Now, you would have basically got a sort of side swipe of what this particular case was from the mainstream media, but it's sort of not finished yet either. It was literally part one, the judgment of the court, of the Supreme Court yesterday in relationship to the Marine and Coastal Areas Act. It's an extraordinary case because, and really it wasn't just one, it was 7 cases that were combined to be heard before the Supreme Court. I'm looking at it, I think there were 24 parties, I could be wrong, but 20-something parties plus the Auditor General were involved in it. And that includes our next guest, whose name is Matanuku Mahuika, which I think is Api's boy, but I'll just check in a second, who's a lawyer representing Ngā Hapu o Ngāti Porou. He'd have to be, wouldn't he? He'd have to be Api's boy, as an intervenor. And yeah, well, let's go and have a chat. Matanuku talks to us now. Listen, welcome to the show. Are you you are Api's boy?
Yeah, yes, I am. It's been a little while since I've been called that, though. But yes, I certainly am Uppy's boy.
I knew your father. I had a great deal of time for him. He was, when I was on the Maori Affairs Select Committee at Parliament between 1990 and 96, obviously we saw a fair bit of him. But he was an outstanding leader of the Ngāti Porou people.
Well, it's not really for me to comment, but it's nice for you to say that.
No, he was.
It's been almost 10 years now since he passed away. He passed away. It'll be 10 years. So
he was an outstanding man. I had a great deal of time for him. Anyhow, well, and so there you are. His son has ended up becoming a barrister and representing Ngā Hapu o Ngāti Porou at the Supreme Court case. First of all, could you take me through this? What's an intervenor? Because that was your role, and I noticed you had a couple of associates assisting you in that.
Yes. So an intervenor, we weren't a party to the original proceedings. And actually we had been, as you'll see from the decision, engaging in a separate but parallel process. So Ngāti Porou began talking to the Crown as early as the end of 2003 about the whole topic of the Foreshore and Seabed. And as you'll know from your own experiences, the Ngāti Porou territory is very isolated. It's largely Ngāti Porou people that continue to live in that area. And one of the features of that area is that Ngāti Porou retained a significant amount of our coastal lands, and therefore, in a very real and practical sense, connection to that coastal environment. And that was the reason why we had this bespoke process. We signed a deed with the then Labour government in 2008 to recognise our interest in the Takutai Moana that evolved with the passing of the new Act in 2011. And we had been happy to stand on the side and watch what was developing. But when it got to the Supreme Court, when the Crown decided to take a specific position, we just wanted to have our perspective heard. So we asked to be heard as, if you like, a non-party to the original proceedings. And that's essentially what an intervenor is.
Now, customary rights, ironically, although they might have a basis in New Zealand on tikanga Māori, really are a British concept, aren't they? And I guess you would have learned that at law school when you did your law degree. Can you just tell us very quickly, please, what you understand customary rights for Māori to be today in 2024?
Well, maybe it's easier to anchor it to the MACA legislation. And I think one of the significant aspects of the Supreme Court decision is the focus of the Supreme Court, or one of the focuses of the Supreme Court, was on the fact that the MACA Act is about reconciling a series of competing, well, I don't know that they necessarily compete, but it were described as competing interests. So that's the the continued Māori interest in, at a really simple level, maintaining connection, but also being able to exercise.
Okay, better go and call him back. Yes, we've just lost him. So, sorry. Now, what Matanuku is talking about here is the Marine and Coastal Area Act of 2011. If you remember rightly, and the very quick history on this is that the Labor government, Helen Clark in actual fact, worried that customary rights are going to be asserted across much of the coast, enacted a piece of legislation, Seabed and Foreshore Act, that caused, as you know, a fair bit of upset in the Maori community. In fact, I think it established the Maori Party from General, or that was its origins anyhow. And the incoming National Party under John Key reversed that particular piece of legislation and instead enacted the Marine and Coastal Area Act, which restored the customary rights of Maori in common marine and coastal areas. And the application of that, I guess, has been in dispute ever since. I hope I've got you back. Are you back? Yes, I think I've got you back.
Yes, I am back.
Cool.
Michael.
Listen,
don't know what happened there.
those customary rights, though, can you just explain what in practical intents they would mean, say, for Ngāti Porou? What's a customary right that, how does it work on a day-to-day basis?
Well, and the context is important because for those rights to be meaningful, they need to have teeth, first of all. But the second and an important aspect for us is that it was never part of our debate around those customary rights that we should be able to preclude ordinary New Zealanders from going to the beaches on the East Coast, from going fishing, and from doing those other sorts of activities that New Zealanders expect to be able to undertake in relation to the coast. You know, we are a series of islands, so access to and use of the coastal environment was always recognised as something that needed to be a given in the context of any recognition of customary rights. So it's really more about, first of all, recognising the connection, and it's secondly being able to have a say, depending on the strengths of those rights, a significant say over activities which might more significantly and perhaps permanently interfere with either the nature of that coastal environment, access to it, or use over it. So we were really focused, and you'll see that one of the things that we negotiated and that found its way into the Marine and Coastal Area Act was the ability to effectively stop the grant of a resource consent that enabled occupation of those coastal areas in areas where we could establish that we have title or we have a right which is sufficiently strong and which has been ongoing that we can claim that we have something akin to a title.
Yeah, and that's important. The Act wasn't going to stop existing resource consents or lawful activities that were happening prior to 2011, but it meant that you had. Did you have an effective form of veto, would you say, or certainly a significant ability to say no to any new economic or commercial development in an area?
Yes, that would be true. And in fact, we did joke at the time when we were talking about those developments. If so for example, you accept that existing or new nationally significant infrastructure would be accommodated without the need to go through that consenting process. And on the East Coast, we joked at the time that we'd love the opportunity to have some nationally significant infrastructure in that area, given its remoteness. So it was the lens that we looked through it at the time that we were undertaking those negotiations. And you talked about my father; he was the lead negotiator for most of that period. I took over that role towards the end after he passed away. But there were two things that were important. The first of all, we needed to protect that customary connection. We needed to ensure that we had an influence over things that would intrude considerably on that connection. But there's an element of pragmatism that came into the negotiations that you would be hard pressed to assert those rights to the complete exclusion of anybody else. And actually, just as a matter, first of all, of our own custom and practice, but secondly, as a practical matter, that's not something that you would want to do or even feel was appropriate to do. You know, manaakitanga is a phrase that gets thrown around, but actually when you talk about mana and you talk about those traditional Māori concepts, actually the ability to share what you have with other people is something which I think at some level enhances your mana and strength of connection. It doesn't weaken it. And so if that's the view that you have around what your customary practice is, then actually it's not a concession at all to agree that, yes, ordinary New Zealanders going to the beach and enjoying our beautiful coastline is something which is enhancing for us, not a negative.